Pad.
Welcome to the Shapiro Law Firm presents a Q&A discussion on child custody and visitation. Joining me today, I am Amanda Schaefer. Joining me today is my co-host, Aaron Shapiro.
Hello.
And since there are 0 watchers at this moment in time, is it working?
So it's working. It's live.
Can you see it on you don't know your Facebook password, so you're not, because I'm on Facebook and it's not, oh, there we go. Okay. Shapiro, I'm the one viewer.
Hello.
Whoop.
Oh yeah, you gotta turn that off, remember?
Yeah, no, I know. Anyways, so welcome as people start to join. Will says it's working. Well, as people start to join us, we will first give our little disclaimer, as we always are required to do. Nothing that we say here today forms an attorney-client relationship. We're here to answer your questions in a general manner. If you have more detailed questions about your case or particular situation, please feel free to reach out to us privately. We, of course, are available for hire. So we will give people—
The best way to reach out is by sending a brief explanation via email.
And
or phone calls, okay.
And if you were, I keep forgetting to say this, but if you are joining us on replay, thank you for watching. And this, you can rewind and whatnot. And what else was going to say? We're still waiting for a few more people to join here. Aaron.
We had a great success. We won a big case in federal court today, and the case was settled and resolved, and the lady's case, everything's perfect. She got her green card. She's very happy. Congratulations.
Yes, that was I did a notable approval on that. And speaking of which, if you don't want to miss any future lives that we do, we invite you to like us and follow us on Facebook and YouTube and then Twitter and Instagram and all of that. We have a lot of other videos that we've done and we'll be doing more. So you don't want to miss it. Oh, and we crossed 1,000 followers today on Facebook. I was going to make that announcement. So that's exciting. We're almost at 1,000 likes. So keep liking us, guys. So we'll get started in a minute. We'll wait, see if anyone else trickles in here. And if you are watching, whether you're live or on replay, if you do have questions, the contact information at the bottom of your screen, please do not hesitate to reach out. So today we are told that there's 2 presidential town halls on today.
Yeah, I watched some. My God.
You do not need to watch those, but hopefully you're tuning in, and if not, you'll tune in on the replay. Anyways, today we're going to get into it now. We're going to talk about trial custody and visitation. Since we primarily practice in New York State, it's going to be a focus on New York State law. But one thing you should know is that all the state laws have a lot of similarities between them when it comes to
Uniform Child Acts that are baselines that a lot of states focus their laws are based on.
Right. So there's the Uniform Child Custody Jurisdiction and Enforcement Act, or the UCCJEA, which we'll talk about a little bit more shortly. But essentially, the UCCJEA, I think all the states are signatories of it. And it's based, well, we'll talk about it in a second because we got a nice little outline for you guys going. Okay, so again, welcome. We're going to start to get into the content. All right. Ooh, types of custody. What?
Sounds like your pizza's ready.
Oh, no, that's my cousin. I don't know how to shut that off on here. Anyways, so types of custody. There are 2 main, so there's different, oh my God, Nick. There are 2 main types of custody. Hold on, let me X out of that. Maybe that will do it. Okay. Anyways, two main types of custody: physical and legal. Physical is also known as residential custody. That's like literally having possession where the child lives, who has physical possession of the child.
Like when we're sitting apart, like, why you little?
Sure.
That's how you end up in family court.
Custody. And then there's legal custody, which refers to decision making. So the important decisions in a person's life, like health decisions, educational decisions, religion, those are the big three. But really anything that's important.
Summer camp. Vacation.
Yeah. Like now, types of custody: sole versus joint. Both physical and legal custody could either be sole, meaning only one parent has that type of custody, or it can be joint, meaning both parents have it. In a sole physical custody situation, there's generally a visitation schedule. In a joint custody situation, obviously the parents have to live near each other. You can't really do a joint custody situation. Sometimes you do have a parent who might have the child still have a superior custody order, like they have them at least 51% of the time. Sometimes it's split 50-50. So like 2 days, 1 week here, 1 week there. It could be weekends and then weekdays. So it's just, the way a custody and visitation arrangement can be, it's really up to the people involved or the judge if you can't come to an agreement. But you can not have physical custody, but you can have joint custody, joint legal custody. And you need to be able to work with the other parent and make decisions together, even though you're not necessarily together, for that to work. And sometimes it does, and more often than not, it doesn't. Because it's a difficult thing to do. And then there is temporary custody and final custody orders. So a temporary or pende lite, if you're in a divorce, that custody, that's usually granted right away. You file a petition. Somebody has to have temporary custody until the whole court case can play itself out or an agreement can be reached. So the temporary orders are I shut off those notifications. Why is it still doing that? Anyways, sorry about that. So the temporary order is not necessarily going to become the final order. And a lot of times the parent who is currently in physical custody of the child will be granted temporary custody, depending on the situation. Sometimes it's who filed first. But again, that's just temporary. That's before you've gone through everything with the judge and, or came to an agreement. But once you have a final order, you have a final order. But one thing to keep in mind about a final order, we'll get to modifications a little later on. Oh, looks like we have a comment. Hey, Lambert. Well, thanks for watching as always, Lambert. He's one of our #1 fans. We appreciate it. So what was I saying? Oh yeah, the final order. I was reading over one of those cases today. The Fried, the best interest case, Frieder-Weitzer versus Frieder-Weitzer. That's like one of the main family law cases in New York. And great quote: "The only absolute in the law governing custody of children is that there are no absolutes." And it's true. I mean, we'll get to some of the when we get to modifications of some of the crazy cases that we deal with. I had one this morning that's been going on for 4 years now. And before that, they were in court for 3.
Yeah, I mean. Mandy, you're frozen. So this case she's talking about has been going on for a very long time. Now, where was she? Basically, you can modify custody orders if things change.
Oh.
There she is.
Okay, sorry. Okay, we're good. So yeah, so we this one case, we think it will go on.
God, stop that thing.
Until the child turns 18, pretty much, because they've basically all but 2 years of the son's life, they've been in court, and the kid's 14 now. And that's not ideal. That is not what we want with these orders. But just to keep in mind, a final order in child custody is as final as not very final.
Yeah, until the kid's 21, it's like always up there.
Or 18, I think.
It depends if someone's paying for college.
That's true. Okay, so who can get custody? The mother and the biological mother and father, or legal mother and legal father, can get custody. Some of the issues that, of course, come up is who is the father. So that's when we have paternity suits. And Aaron, you want to talk about this for a second so I could figure out how to shut this off?
Sure.
Because, thanks.
Basically, I can tell you a story. Obviously, you know that when the baby comes out of the mother, they know who the mother is. But it's very possible for the father to be unspecified, unknown, not guilty. I mean, lots of things. So we had a client that met a girl, got her pregnant, and the first time they met, and it was the very first time he met anybody. And she got pregnant, and he didn't believe he was the father. And he went and had to do a paternity test, and the child did the paternity test, and he was the father, and he's never met the child, and he will never meet the child, most likely. And he's paying every penny of child support, doing a great job. And it's a strange situation, but it sort of is working for him, and the child is being taken care of, and he's just not part of the family, really. But that's one of those situations where, undetermined. He does not have legal custody of the child. He does not have physical custody of the child. So
who the legal father is can be determined in a couple different ways. One is obviously a DNA test can show it, but you need to have the father sign an acknowledgement of paternity or have a court order. If the father's listed on the birth certificate, there's a presumption that he's the father. So if you're the legal father and you want custody or visitation, then you can go to court and file. And what's important to remember is that no parent has a superior right over the other parent. If you don't have a custody agreement saying who gets physical custody, then when you walk in the door, you're equal. It's going to change once facts come out, of course, but it's not like some people think that women are favored or, the moneyed spouse or ex-spouse is favored. That's not the case. And I can't speak for every state, but because I have heard sometimes, even in today's day and age, that there are some courts that are more likely to favor mothers over fathers, but not in New York and not in my experience, at least. And then, grandparents, relatives, friends, if they come into the picture here, they're not going to have a superior right to custody over the parents unless there's some type of extraordinary circumstance, like the parents surrendered the child, they didn't want to be parents, they abandoned, there's some type of persistent neglect, the parent is unfit because of either mental illness or drug or alcohol use, something like that. Otherwise, anyone else besides the legal parents will not even be heard in a court of law. So what is visitation? Well, essentially visitation is for the non-custodial parent or non-physical custodial parent, and it entitles that parent to meaningful access to the child. There is an unfettered right of each parent to have parenting time, which is another term that's used instead of visitation, with their children. And the only time that really changes is if it's going to actually be harmful to the child. And I always tell clients when they come in with and express any type of concern about the other parent being with the child, that there's ways that the court will handle it, like starting with supervised visitation. And that would be where they go to, what's the name of the agency? It's not ACS. That is an agency, but there are certain agencies where you can go to that will you'll have a supervised visit in, so you go for like an hour with the
You do it at
child.
the police station. They do it at the park. You do it all over the place.
That's a little different. I'm talking
You do it
about
at the park. We've had a client that did it at the park, or a client that did it at the mall.
Yeah, I'm talking. That's like the second step. I'm talking about the
I
one
don't
where
know
they.
anything about the agency. We've never used an agency.
We've had clients do this before, but where they go for like an hour, they observe them with the child, and then they write a report. It's usually with an abuse and neglect case when it's that.
Oh yeah, that's during the investigation stage, though.
No,
That's like when they're still watching the whole thing.
Doesn't matter. Point is, other types of
solution. It's only a temporary thing, though.
Right. No, I know that. So the other types of supervised visitation would be what Aaron said, where you meet in a mutual place, you have a third party there to make sure like that.
Yeah, this is the most common.
That's pretty common.
Police station.
But the thing is, no matter what, supervised visits aren't going to last forever unless the parent cannot show that he or she is capable of taking care of the child or is responsible or trusted. And if the visits go well, they do eventually progress to regular visitation with no supervision. It starts usually with like a day visit, a couple of hours, then an overnight, then maybe a couple of days. So because each parent does have that right unless they choose not to exercise it, or again, it's been proven to be harmful to the child. And it's important that both parents understand that and encourage the relationship with the other parent. Initial custody determination. So what do you do if you want to get a court order for custody? Well, you will go to either the family court or the Supreme Court. And these are the two different places you can file, and there are some important differences to think about.
You don't need to tell them all these differences. Just hire a lawyer. Just hire us. We'll get you the kid.
Well, I'll just sum up the differences. If you're not filing for divorce, it makes in New York State almost no sense to go to Supreme Court. It will take longer. It'll be costlier. It just doesn't make sense. The nice thing about, though, if you are getting a divorce and you have minor children, all of the issues, child custody, visitations, child support, and the divorce can all be handled by the same judge. Family court, child support is separate, always separate from custody and visitation. So if you have a custody order, you do not automatically get child support. You then have to go see a different judge. Once you have a divorce decree, or any type of custody order or visitation order, you can go to either court after the fact to enforce it or modify it. Again, 9 out of 10 times, unless there's something very different about the case, you're gonna go to family court. There's no filing fees, etc. It's an easier process.
It's made for that.
What?
It's made for that.
Right, it's made for it. Whereas the other judges, they handle all types of cases. So here is the important question. How does a court decide who to award custody to? Well, the first thing the court has to do is determine if it has home state jurisdiction. Now, if mom, dad, and the child all live in the same state, that's easy. The court has home state jurisdiction. However, which is very we have a lot of cases like this where only one parent lives in New York, whether it's the custodial or non-custodial parent, and the child might live in New York and might not live in New York with the other parent. And if you have parents living in different states, the question is which state should make the order, because as I said earlier, all the states are required to respect the orders, child custody and support orders from other states. So you're going to get your order one way or another, but obviously if you live in New York, it's a lot easier for you to show up to, even though today we're not showing up for court in person, it is still easier for you to handle a case in New York. So you might want to know, well, how can I ensure my case is in New York if the other parent doesn't live here? So if you don't have a previous order, we're starting from scratch here. The main thing that we look at here is that Uniform Child Custom Jurisdiction Enforcement Act, or UCCJEA, which again, that governs, it's the law that basically says that the states are going to honor each other and how to determine which states have jurisdiction over the others. Each state still has their own laws, but and can still take precedent over it, but it's kind of like the guide if we're deciding here. And it talks about emergency jurisdiction as well. And
6 months, home state rule, 6 months. Where the kid lives 6 months.
Where the kid has lived the last 6 months before filing is generally but it's actually a lot more complicated question than that. But in general,
lawyer.
That's what, right? Yeah, I'll
hire a lawyer. Don't even bother with this.
So once the court determines that it has jurisdiction, now it has to determine what are the best interests of the child. This is the most important thing always when we're dealing with child support. Child custody. And I say this all the time when to my clients that no matter what we do, the first thing we have to be able to say is this is in the best interest of the child. And so how do the courts determine what's in the best interest of the child? They do what's called the totality of the circumstances approach. There's no one factor that's going to do it or is going to make the court decide in your favor. It's a weighing of all different factors. So some of those things, they include like the mental health of parents, physical health of parents, if there's been abuse allegations, if there's been any neglect, the finances of the parents. Like even though you might get child support, you still have to be able to support your child on your, in your own right or in conjunction with the child support. Stability. Do you have a stable job? Do you have a place to live? Do you have a bed for the child to sleep in? Is it clean?
Do you do drugs or alcohol? Do you have sex with random people? Are there bad people around in your home? Is your home safe for the child? Are you going to be absent? Are you going to be present?
Right.
When can you pick the kid up? When do you go to work?
Have to work. Are there siblings?
Where they live.
Court is always going to want to keep siblings together. The judge will also look at the parents' behavior at court. So if you're someone who acts up and the judge is yelling at your lawyer to get get control of you, that does not look good. Because the way you present yourself is going to have an impact here. And then another incredibly important thing, I mentioned it earlier, the willingness to foster a relationship with the other parent. And what that means is that no matter what has happened between you and the other parent, I don't care if it was like a one-night stand or a 20-year marriage that went south after being cheated on or something. I don't care how bad things got between you two. It's not about you two. It's about the child. So and every court agrees that what the best interest of the child is to have both parents involved unless it's harmful to the child. So, 99% of the time, it's not going to be harmful for the child. And if you're the custodial parent, if you don't let your child talk to the other parent, or you don't follow any type of visitation schedule, or you make things difficult, you don't answer questions, that's going to be a really bad look for you in front of the judge. And you might not get custody because of that. We had a case recently where the parent, she said she was afraid of her soon or now ex-husband, and that she didn't think he was a fit parent. And she took her son one day and just left. And then he didn't see his son for 2 months. And that haunted us the entire case. Even though she was legitimately scared of him, he never physically harmed her, but there was a lot of psychological harm. The judge didn't care. The judge only saw that she took her son from him and didn't let him see him for months until the attorneys got involved. And that's a really good lesson to learn. Before you do anything like that, you have to think about how is this going to look, because your goal should be to have both parents having a good relationship with your child. And that's what you're going to have to do if you're the custodial parent.
And the reason is because it's not about you.
Right. Like I said, it's not about
the
you.
Child. The kid's going to wonder, why am I not seeing the parent, right? So you don't think about it from your own self. You have to get rid of your ego.
It's true.
Yeah.
I mean, we today, this morning, I had an argument in a child custody case where I was arguing to the judge that the mom, we were representing dad, that mom, her opposition to what we were doing, like they needed to relocate because of our client's job. Her opposition was selfish. She wasn't looking at the fact that it'll be easier for her to see her son. She only cared that to oppose her ex-husband because she hated him so much. So everything he did, no matter how much it would help the child, she objects to. She makes it difficult. And it's not, she's trying to get custody. She's not going to. Not when you act like that.
No.
And if you're just joining us and you do have questions, please don't be shy. We're here to help. If you want to ask questions anonymously, you can email us and we'll try to switch back and forth and keep an eye on that as well. So yeah, the best interests of the child, that's going to come up, whether it's an initial custody.
Paramount is everything.
Everything, or a modification.
Even when we get into child support issues, it even comes in there too. Everything.
Yes. So, modifications. How can you get a change in custody? Basically, you need to have a substantial change in circumstances from when the order or agreement was first entered into.
Yeah.
What is a substantial change in circumstances, Aaron? Aaron?
You're asking me. I mean, you're the lawyer. I don't know.
I'm the lawyer. So are you. Well, the reason Aaron's is struggling to answer that question because there's no simple definition of that. It's another totality of the circumstances approach.
Yeah, every time our clients come to us, it's a substantial change in circumstances.
There are certain.
It could be geographic. It could be.
Well, we'll get to geographic in a second.
It could be one of them became a drunk. Maybe they've got some sort of an illness. Maybe they lost their job. They can't support it, and they're having problems. Maybe they lost health coverage. I don't know. It could be a million things.
Right. Big ones are interference with the other parent's access to the child. That I would think is the number one substantial change.
Moving away.
Well, I'll get to relocation shortly. But essentially, yeah, if there's some type of mental health issue, physical health, drug, alcohol abuse, things like that, it has to be something substantial though, because the court always wants to do things that will keep the environment stable for the child, and moving around, changing custody is not stability.
Continuity is key.
Continuity, yes. So no matter what, even if there is a substantial change in circumstance, the conversation is not over, because we still have to prove that the change in custody or the change in visitation schedule or whatever it is in the best interest of the child. And those factors we just discussed about the best interest of the child, they come into play yet again. In addition to that, the court does look at the initial agreement. And although I said earlier, nothing's ever final with child custody, it isn't controlling, but it certainly informs the judge, and like something that both parties consented to will hold up in the face of a modification better than one where it was contested, you had a trial, and the judge made the order. So there are things that are important about the old order. It's not like we throw it out the window or anything. But because it is really hard to change. It is going to stay the same unless there's really something substantial that's changed. And you can consent as well to a change of custody. We've had a case like that before, where the mom lost her job and where she was living and couldn't keep custody of the children. I think I talked about this the other day on notable approvals. You should check that out. And essentially, she went to the father and said, "I need you to take the girls. I can't take them anymore." And it was a good thing that he did, because there were a lot of other things that went on. But we got to court and we told her to get a lawyer. She said, "I don't need a lawyer. This is what I have to do." And then we got to court. Judge says, "Do you want a lawyer?" She said, "Yes." And then we got adjourned. But it's always better with a lawyer, because you can't. We wanted her to have.
You're going to appeal it anyway.
Yeah, it will get appealed.
Judges don't want cases without lawyers because they will appeal them.
Right, but in the family court, it is kind of set up to make it easier if you don't have a lawyer. But if you can't afford a lawyer in family court, you will have one appointed. That is not the same in Supreme Court. Other types of modifications deal with relocation, and this is a biggie. So in terms of relocation, again, stability, best interest of the child analysis comes up. Stability is very important. The court's going to also look at a previous order can limit geographical location of the child. Sometimes you'll see orders that say that you can't move outside a 50-mile radius or something. So we've seen orders where it affirmatively gives the custodial parent the unilateral authority to choose where the child's going to live. And sometimes it's silent. So it could be any of those situations. But if you do have an order that says you can't move without consent of the court, like a court order or consent of the other parent, you need to go back to court with a modification petition in order to change it. And the court's going to look at, is this change, where are you relocating? If you have lived 5 minutes from the other parent and now suddenly you're moving to California, you got to have a really good reason, because that's going to significantly interfere with the quality and quantity of the visits with the other parent, their type of relationship. There's a time difference. So the court is not going, even if it's like, look, I got a promotion, I got a better job. Well, the court's going to say, did you look for jobs in New York, or New Jersey or Connecticut or somewhere where like you would, see the parent more. Obviously, it's a little different if you guys already live 1,000 miles apart and you move 1,500 miles apart. But is it easier to get to the airport? Are there direct flights? Are they cheaper? Sometimes transportation costs play a big factor in the visitation schedule. If one or both of the parents can't afford the transportation costs, then one of the parents is not going to have visitation, and the court is not going to be okay with that. So,
bad for the child.
What?
It's bad for the child.
Yeah. And again, and it's not just about parental access. It's about, what's the educational opportunities like? Are the schools drastically worse for the child? Is that going to be an issue? How's it?
Healthcare, crime rate.
How is this child with change? Maybe this could be a child that's used to change, like a military child that's used to moving around and isn't really fazed by moving to a different state every year. Whereas opposed to somebody who's lived in the same place for 10, 15 years, and all of a sudden the parent's like, oh, I want to leave and go somewhere else. So
in her junior year of high school.
Right. One thing to keep in mind, if you're going to have a baby with somebody, just remember that like this child is going to tie you to, and you should make sure you really want to have a baby with that person, because you're going to be inextricably tied, at least until the child is an adult. And you might not be able to, you might hate that person, but you're going to still have to see that person for visitation, and for drop off some pictures.
This video.
Well, maybe they are, because they don't know how to deal with it. I don't know. But the point is that when it comes to having a child, these are really very real. If you're planning it, just make sure it's the right person, because this is somebody that you can deal with, because otherwise you're going to run into a lot of problems, especially if you want to pick up and move. If you have a child, it makes it a lot more difficult if there's some type of visitation order in play. Which brings us to violations and enforcement. And again, if you're just joining us, welcome. If you have questions, don't be shy. We've gone through a lot already, some very important things about child custody. And now we're going to talk about what happens when someone does not follow the custody or visitation agreement. So what are violations? Violations are not following the schedule. So dad has the weekend and mom doesn't drop the child off and won't let dad take the child. That's a violation. Being late to pick up and drop offs, like consistently late, is a violation. Not letting them your child communicate with the other parent's a violation. Some of the case law talks about taking a child out of school to be a violation, or picking up the child without the other parent's knowledge from an activity or school, that's again a violation. So what options do you have when you have a violation? You have three main options in the state of New York. One is file a violation petition. One is file an enforcement petition, which are very similar. And in an emergency situation, you have a writ of habeas corpus, which means to show the body. And these are filed in emergency situations where there's some type of alleged risk to the health and safety of the child. And it actually directs the parent who has the child to bring the child to court and show that the child is okay. That's like the very basic underlying definition of what it is. Essentially, though, it can create a temporary custody order. It can lead to a final custody order. We've had this done where a parent threatened to take the child out of the country and move out of the country, and the other parent wanted to stop it. We've had this situation where, generally they go hand in hand with like kidnapping claims. Some type of serious violation where the health and safety of the child is in jeopardy. But they work in a similar fashion to filing a violation or enforcement petition. So what exactly are the consequences if you or your other parent in the relationship violates one of these orders? Essentially, the biggest thing that can happen, I think, for a parent is the loss of custody. If you, again, are not encouraging the relationship or like affirmatively preventing the relationship from happening or cutting off communication, you can lose custody of the child. And the courts take that very seriously. You cannot talk bad about the other parent either, no matter what has happened between you and the other parent, not about you, about your child. And it is not in your child's best interest, no matter how old he or she is, to disparage the other parent, no matter what. You also should not talk about the court proceedings. That's another big thing that happens a lot. That don't get the children involved. You're just traumatizing your own child. That is not a good look. You could be found in contempt of court. You could be asked to pay fines, in very rare fines and attorney's fees too for the other side. And then in very rare circumstances, you can be given a jail sentence of 6 months or less. That would be for someone who's a repeat violator, who is not getting the hint in any other way. And, eventually the judges are going to get frustrated and send someone to jail. Now, another way you can get sent to jail is if you do not give your child back. And like, if you have a visit and you don't give the child back and the other parent calls the cops on you, you can get arrested for that. Again, more likely than not, they're going to say give the child back. But if you're someone who does this repeatedly, it can happen. It is a possible consequence. Child custody and child support. They have nothing to do with one another. In terms of a biggest question, if the other parent stops paying child support, do I have to let them have their visits? Yes, you do. Child support is your child's right. It's your child's money. Yes, you give it to the parent to support the child, but ultimately it is not the other parent's money. So and it's not tied to child support in the sense of if you don't pay child support, you lose your visit. That is not a consequence. And so pay your child support, because you should support your own kids and not be bums. But not just that, they're just too, they're even, like I said, in family court, you're not even seeing the same judge for these issues. And a lot of times you see in child custody, disputes, one parent bringing up the child support issue, and the judges won't even let that evidence come in, except if you're going to the financial capability of the other parent to even have the child. That does happen, but generally speaking, They are two completely separate issues. So just because you didn't receive your check that week, it doesn't mean that you can cut the visits off. You'll be in violation, not the other parent. Although they'll be in violation of the child support, but that's a different thing altogether. And then immigration, because we do a lot of immigration law and child custody. I kind of put this topic up to if people had questions about it. The big things to know is in regards to your immigration status. If you're in a custody dispute, if you're not a U.S. citizen, the U.S. citizen doesn't have superior rights to the child. Issues that have come up in these cases will be if a parent plans to take the child to another country or to live in another country, and there's a reason to be concerned about the child's safety in that country. That can come up. But when we're dealing with immigration status, it's not related. When we're dealing with filing immigration, like for an immigration benefit for a child, in terms of physical custody, it only comes up in like the automatic the derivative citizenship, right? The naturalization. Mm-hmm. That you have to be in custody of the U.S. citizen parent for a certain period of time. It comes up in that situation, but your children can be living in another country, and if you're a U.S. citizen or a permanent resident in certain circumstances, you can file for your child, even though they're not in your physical custody. In terms of showing relationship, the laws still do make it easier for women to show their relationship with the child. You just have to show your names on the birth certificate. But we have actually had a client who, remember the client who is the biological mother of the child, but they made her get a DNA test. Mm-hmm. She had to get it for 3 of her kids. And that's because she left the kids off of her immigrant visa application years earlier. That can make them question it. And then they also questioned it because they registered the birth certificate so like 18 years after the kid was born, or I think she had to make it a change on there. But that it can be questioned. The mothers can be questioned like the fathers, but with the fathers, now the law basically says if your name's on the birth certificate, you're presumed to be the father. But we have had them require showing support before. We've had to have our clients go get DNA tests to prove they're the biological father, even with their names on the birth certificate. So it is an important issue with immigration when it comes to filing or petitioning for the child, or child petitioning for you. Well, it doesn't really apply if the child petitions you because the child has to be over 21. But for you petitioning for the child, and then the other times it comes up is in cases like with certain types of hardship waivers, and in cancellation of removal. So certain types of hardship waivers, if you're inadmissible to the U.S. for some reason, whether not crime, it doesn't cover crime or fraud or it doesn't cover fraud and misrep, but it covers certain crimes. You have to show an extreme hardship to the child. If you don't have physical custody of the child, it's going to be hard to show that your child is going to have a hard time if you're not here in certain circumstances. And cancellation of removal, you have to show an extreme and unusual hardship. A U.S. citizen or permanent resident child is one of the relatives you can show that to. Again, you have to actually prove you have custody and where the other parent is, and if the other parent contributes and sees the child, and why can't the child stay here if you have to leave the country? So that's really when it comes into play. But your particular immigration status is not going to have a bearing on a child custody proceeding. Anything you want to add about that, Aaron?
No.
Okay. Well, on that note, if there are any remaining questions, we've had none this time around, but apparently
they're all watching the president.
Yeah, I did
not duke it out against each other because neither of them is.
I mean, honestly,
very odd.
I think it's a waste of time to watch those things.
I just like to see how Trump responds to negative questions, and it's not good.
Oh, apparently it was pretty entertaining. We had it on for a few minutes earlier before, but I didn't know that was on today. So, but I'm confident people will watch this on replay. So if you are and something that you saw here raises a question, or you need a lawyer for your own case, we're happy to help you. Oh, one thing I forgot to mention that's really important is if you have minor children and you're trying to get a divorce, in the state of New York, it is, I've heard of it happening, but I've not seen it firsthand. Like almost, I would say impossible, but almost impossible to get a divorce without settling the custody, visitation, and child support issues.
I saw it.
I know we saw it in a divorce, but we don't know what happened.
I believe they probably said that they just reserved it. It was like, must have been an outside case, like child custody. I can't imagine it either, because I think the law says that they have to have all the issues wrapped up.
I thought, but I think they had pending cases in the family court that for some reason wasn't joined, and that the judge allowed the divorce to become final pending it was final, and then it's like
they're going to incorporate the decision or something.
So you definitely, if you don't have those other cases going on in family court, that we 100% know you're not getting divorced without those issues being settled. But I don't think it's that simple, because they don't want you to have to keep coming back to court. They want everything done and taken care of. So a lot of times when people want to get divorced and they ask us, like, is it going to be simple or easy? New York, you have a contested divorce and an uncontested divorce. You're not getting an uncontested divorce unless you either don't have children and assets, and you're not looking for any spousal support, or you have an agreement on child support, custody, and visitation before you go to court to file the divorce.
Which is a great idea.
Yeah.
But then you get stuck with modifications. So there's ups and there's downs to everything.
Yes. And we've also had the situation where a client did not tell us there was a minor child because they wanted to just get divorced and be done with it. And then they tried to file for child support. And guess what? They did not get child support because they essentially committed perjury by signing an affidavit.
100% committed perjury.
Right. Because they said they didn't have any children. I think in that case, there was an affidavit, the one I'm thinking of, we had an affidavit of defendant too. The defendant also said there was no children of the marriage. But either way, it doesn't matter. If you're going to try to go to get child support after the fact, it's not going to happen. And if you filed an uncontested divorce and there was a default, and then the other parent files for custody, you can end up losing custody because you lied about it as well. So, again, we'll wrap up now since I went through our outline and we haven't had too many questions. Oh wait, I see a comment. What's this?
Lambert.
Oh, Lambert. That's
Thanks
Lambert.
Thumbs up, Lambert. It means a lot for hanging on this long, buddy.
We appreciate it. We hope you found it interesting, and everybody else as well. So yeah, if you have any questions about anything that we talked about today, or you need a lawyer for your case, we are more than happy to help you. We've had cases. We end up handling a lot of interstate cases where we have one parent, either we represent the parent in New York or not in New York. I've had plenty of clients I've never met before in person. Today, it's easier with the virtual court, just because you don't have to go to court. It's a good time to get divorced. In that sense, it costs a lot more money for all of these things when we have to go to court.
Just save time. Saving time, saves money.
These things are not flat fees. They're billable hours.
Oh, yeah.
And And one thing that I want to stress is that one thing that's always in the best interest of the child, always, is not having litigation and being able to agree with the other side. So when our approach, whenever we represent someone in a case like this, no matter how contentious it is we always try to find some type of ground of agreement and start from there. We try to keep it out of court as much as possible. We try to push our clients towards settlement, because when you're unless you have a legitimate reason not to come to an agreement, you're not going to look good in front of the judge, because they don't want to see that. It hurts the child to put a child in the middle of things like this. So we take that very seriously, that we try to convince our clients, always to see, can we reach an agreement here? Can we give a little? Because at the end of the day, you need to learn to get along with the other parent. Otherwise, you're going to, like the case we talked about earlier, end up in court until your child turns 18. And that is not ideal. You will not be happy paying your lawyers for years and years and years. So, so basically that's all we have for you today. We thank you all for watching. We hope you found it interesting. Again, if you're watching this on replay, we're always available. Contact information scrolling across your screen. We'll be back in in 3 weeks with another live. We haven't decided the topic yet, but it'll be another interesting one for you. So make sure to follow us, like us, Facebook, and all those places so you don't miss any more. We'll have some more notable approvals for you as well next week. We appreciate everybody, especially Lambert, watching, and we hope that you all enjoyed it and have a great night.
Good night.